What are the legal aspects to raising capital as a private or public unlisted company? So this is a question that we're commonly getting more and more lately, and I think it's an important time to really have a conversation about it, because as this space has grown, what's happened is a lot of the rules that were sort of strongly enforced, people have seemed to have forgotten about or really not following as much as they should. So this was really designed for you as a founder to make sure that you're protected in this process as you're going through the capital raising. Now, this is obviously general advice. I'm not a lawyer. We have been working in this area now for the last 12 years, and we've been working with companies. And effectively, the way we've structured WI in some ways is as a platform so that companies can actually legally raise capital as a private company. And there's certain things that we had to do in our structure and in our setup to make sure that that is, suitable for companies. And I think if you're a company that's raising capital, and let's say you're not using someone like Wholesale Investor and you're using another platform, I think there's some important things that you need to ask. Now, there's 3 different types of platforms that you would typically come across when you're raising capital. Number one is, the first one is just a traditional AFSL licensee. So if you're working with a corporate advisor or you're working with, an investment group or something like that, typically they're working under an Australian financial services license, and they have the ability to deal in securities as part of that. Now, some people have different licensing requirements, and if you effectively at the bottom of their website, they will have that license on there, and it's very easy for you to do a Google search and go and understand what capabilities they can do under their license. That's step one. Step 2 is typically an equity crowdfunding license. So that's obviously become a lot more popular over the last few years. I think there's been about sort of 15 of them handed out. So if a company is using an equity crowdfunding license, once again, you will notice that on the bottom of their site, that is what they'll be operating on. And also you'll notice that when you actually register on you'll notice that when investors actually register on their website, there'll be certain disclaimers and certain processes they have to go through by law as part of that. And I think that's an important acknowledgement as part of the framework that's been set up under that legislation for companies that, especially the B2C companies that have done well with raising capital under the equity crowdfunding license. Now, for other platforms, and this includes us as well, such as Wholesale Investor and also CRISP, we work under the Class Order 02273 regime. And with that, there's certain things that we need to do as part of that. So couple things that you need to make sure that you do. First, you need to oblige by the 2012 legislation. So the 2012 legislation is really making sure that you don't have more than 20 retail investors, which is effectively mum and dad investors, across a 12-month period. Now, for us, obviously, we target high net worth and wholesale investors, and we encourage our clients to ask their investors for a sophisticated investor certificate, right, which will not count as an allocation under that 2012 legislation. So you can raise capital from retail, but you cannot raise more than from 20 investors across a 12-month period under the class order which we operate under. Now, another important aspect to that is the definition of a sophisticated investor is someone who is making over $250,000 a year or has over $2.5 million in net assets. The third element to that is that they invest over $500,000 into your opportunity. If either one of those 3 criteria are met, they are able to supply you with a sophisticated investor certificate, which is signed off by their accountant as part of the actual process of investing into your company. Now, as with Chris, the way we've set it up is that basically investors can upload that to the platform, so it's on file at all times. And technically what they need to do is typically, I think they need to update it sort of once every 2 years. But once again, get your own legal advice. I'm just providing a high-level general overview. And the other thing I'll say is if you are working with other platform providers, there's a few things that you need to do. Firstly, look at their website and understand what legislation they are working under, or what license regime they are working under. If you do not see this on their website, that is a big risk for you as a company. So to explain this really clearly, if you are raising capital illegally, the investors that come into your business can at any stage basically create issues for you as a founder when it comes to that legislation. So if you have raised capital illegally, they've got the absolute right to basically not only demand that money be returned, but if you are unable to return that money, then you are going to have issues for yourself as a founder. So I like to highlight this for founders, because the reality is most of us are so focused on building our businesses, and capital raising has just become such a commonplace conversation that we're not quite aware of the risks that go with it if we do it incorrectly. And unfortunately, you only typically find out about these risks if you do it wrong and if you've got challenges down the road, and that is not the way you want to find out about it, right? So that's an important part. So a few things you need to, if you're looking at using external platforms, then effectively look at the licensing that they're working under or which regime they're working under. Secondly, you need to ask your platform provider how they have actually sourced their investors, and you need to ask the question, have the investors in which are looking at their opportunities signed off on the appropriate legislation required material as they've been onboarded onto that platform, right? Because that is also an important part of this process when you're actually going to raise capital. Now, for Australian companies, if you're dealing with international investors, that's not fine. That's a different process, right? But effectively, the Australian legislation is really sort of focused more around protecting the Australian consumer investor, which absolutely makes sense, right? So understand that as in mind. Now, the next part is that if you really want to understand the risks that go in doing it wrong, then you need to understand that any capital you raise outside a licensing or a framework that has been set up to ensure that capital raising is done legally is putting you, the years of work, and everything that you've invested into your company at risk. Right? So it is absolutely your duty as a founder to ask the platform operators that you're working with. So firstly, have a look at their website, as I mentioned. Make sure they've got the appropriate licensing or framework on there. Then you need to understand for the investor onboarding as well to make sure that that's also being signed off in the correct and appropriate way. And then from there, if that is the case, then from your perspective, you know that you've done the right things. Obviously, in your pitch deck and in your IM, they'll typically have certain disclosures as well. And then the last part is if you're bringing on a sophisticated or an accredited investor or a professional investor, then make sure you just ask for a certificate as part of that process, and do not go over the 2012 allocation. Us as founders, we work day and night to build our businesses, and the last thing that you want is to have an issue is because of an oversight oversight on your part, or because of an operator actually not taking the time to go through the appropriate legislation. Hope that's been helpful, and look forward to providing more videos shortly.